Well, hello all and welcome. We'll go ahead and begin this webinar. This is the second event in the Notre Dame Law School's Global Spotlight Lecture Series. This series highlights the law school's new global lawyering initiative, which our Dean Marcus Cole launched last year. And the goal for this initiative is to establish the law school as a leading American law school for global engagement and opportunities for students, faculty, and staff. We aim to support teaching and research collaboration among our faculty and scholars around the world. The Global Lawyering Initiative capitalizes on the University of Notre Dame's network of campuses and centers around the world, including in London, where the law school has operated our London Law program now for more than 50 years. And the Notre Dame program in London is the only year-long study abroad program that's been approved by the American Bar Association. Now, as part of this new initiative, we're engaging in a major reinvestment in that London Law program. We're overhauling the curriculum, we're strengthening ties between our teaching and research programs in London and our various other campuses. And we've been recruiting and appointing first-class scholars from the UK and around the world to teach in our program. And one of these outstanding lawyer-scholar recruits is with us today to discuss coronavirus and the curtailment of religious liberty. Professor Mark Hill, QC of King's College London is with us. Professor Hill is, among many other things, an adjunct professor at Cardiff University, the University of Pretoria, King's College London, and the Notre Dame University Law School in Sydney, Australia. He's a distinguished fellow of the Center for the Study of Law and Religion at Emory University in Georgia. He's the chairman of the Ecclesiastical Law Society. He's the vice president of the International Consortium for Law and Religion Studies, and he's a member of the editorial board of the Oxford Journal of Law and Religion. His recent publications are too numerous to count, but I'll highlight just a few. The fourth edition of the practitioner text, Ecclesiastical Law, which came out in 2018. The volume Great Christian Jurists in English History from 2017, and he's co-editor of the Routledge Handbook on the Freedom of Religion and Belief, which is coming out in 2020, and he practices at the bar in London. Also joining our discussion, we're very pleased to have Professor Arif Jamal. Professor Jamal is an associate professor in the Faculty of Law at the National University of Singapore. He was educated in Canada and in the UK. He completed his PhD at University College London, and he's the author of Islam, Law, and the Modern State with Routledge in 2018, and co-editor of Regulating Religion in Asia, Norms, Modes, and Challenges, which was brought out by Cambridge in 2019. Arif's research and teaching interests include law and religion, law in Muslim contexts, and legal and political theory. Our third distinguished guest today, Idowu Akinloye, a lecturer in the Faculty of Law at Crowther University in Nigeria. He's also a self-supporting priest in the Anglican Church, both in Nigeria and in South Africa, and a barrister and solicitor of the Supreme Court of Nigeria. He holds honors degrees in law and theology from Delta State University and Archbishop Vining College of Theology, respectively. He has his PhD in law from Rhodes University, focusing on law and religion. And Idowu was recently awarded a 2020 Young Scholars Fellowship on Religion and the Rule of Law by the International Center for Law and Religion Studies. So thanks to all three of our guests. We're going to begin with Professor Hill, but first, just two quick technical notes. We're going to have time for questions once the speakers have concluded. Please submit your questions using the Q&A function at the bottom of your screen with Zoom. And of course, if you have any technical issues, I am completely useless to you, but there are people who can help you, and please use the Q&A function for those as well. And then finally, I just want to thank those who made this webinar possible, including my colleague, Professor Michael Addo, who's the director of the London Law Program, my colleague, Professor Paul Miller, who's the law school's associate dean for international and graduate programs, my colleague, Dr. Felicia Caponigri, acting director of international and graduate programs, my colleague Stephanie Barclay, who's going to be co-moderating with me today. And then finally, Jean-Marc Brosseau, who's the graduate programs manager for the Notre Dame Law School. And with that, let me turn things over to Professor Mark Hill.
Thank you, Rick, and good afternoon. It's a pleasure to be here, and I am speaking from my home in central London, just a few hundred yards away from Notre Dame University's very prestigious Global Gateway campus in Trafalgar Square. I too am indebted to Professor Michael Ajayi, the director of its London Law Programme, for inviting me to give the principal paper this afternoon. The campus, as you know, is closed as a consequence of the COVID-19 pandemic. And it is this very virus which has prevented our physical presence, which will form the subject matter of my paper. I'm delighted that Professors Rick Garnett and Stephanie Barclay are moderating this seminar. They're doing so from sunny South Bend, and that Dr. Idowu Akinloye in Nigeria and Professor Arif Jamal in Singapore are poised and ready to respond in case I make an interesting point. Professor Jamal is very generously staying up way beyond his bedtime in the Far East, so as a kindness to him, I will crack on with my paper while he is still awake. The rest of you can peacefully slumber in whichever time zone you happen to be, with the mute function firmly engaged. Let me begin with a quotation. Every public health emergency must always be handled within the framework of the rule of law. The alternative is social chaos. That statement could have been made by pretty much any judge in any country over the last 7 months. In fact, the words were spoken by the High Court of Malawi in a judgment concerning the lawfulness of certain curfew regulations. The quotation provides the stepping off point for my paper, assessing and evaluating the constitutionality of government action in response to the coronavirus pandemic, particularly, as my title teasingly puts it, in the curtailment of religious liberty. Time does not permit me to deliver the paper in full, although the text will be made available to those participating in this virtual seminar. So I begin with an observation of a British judge. He described the lockdown which has been brought into force in the United Kingdom as possibly the most restrictive regime on the public life of persons and businesses ever, certainly outside times of war. And in my introductory chapter to the forthcoming Routledge Handbook of Freedom and Religion of Belief, where Professor Jamal is a co-editor, I observe that the COVID-19 pandemic has led to a resurgence of authoritarianism, civil rights, including freedom to manifest religion and belief, have effectively been suspended in consequence of a global health emergency. Severe limitations on personal and associational autonomy, unthinkable in normal times, have been imposed in circumstances in which most major faith groups have been complicit and supportive. So first, an outline of religious liberty in its general terms. Freedom of religion is not an absolute right. It is to be expansively interpreted, but subject to certain limitations, the boundaries of which ultimately fall to be drawn by the judiciary. It is one of a suite of rights contained in international declarations and conventions. Take, for example, the European Convention on Human Rights, not as a paradigm of best practice, but as a representative example of the architecture of both the primary right and the legitimate limitations. The first part of Article 9 sets out the content of the right, while the second part specifies the grounds on which the right may be limited. The right to freedom of thought, conscience, and religion is absolute and may not be restricted. In contrast, the right to manifest one's religion or belief in worship, teaching, practice, and observance is subject to the limitations expressed in Article 9. These include public safety and public health. And the Strasbourg Court has developed a methodology which consists of addressing sequentially the following questions. First, does the complaint fall within the scope of Article 9? Second, has there been an interference with the manifestation of religion? Third, is that limitation prescribed by law? Fourth, does it pursue a legitimate aim? And fifth, is it necessary in a democratic society? On points 1 and 2, the burden of proof lies on applicants to demonstrate that restrictive coronavirus provisions have prevented a manifestation of religion. Once that is discharged, the burden then shifts onto the government for the remaining points 3 to 5 to demonstrate the lawfulness of the restriction, its purpose, and its necessity. And here we enter into the realm of proportionality. The necessity must be of such a gravity as to trump the exercise of religious liberty, and no less onerous provision must be possible. Now, commenting on this in April, the Council of Europe issued a toolkit for member states respecting democracy, rule of law, and human rights in the framework of the current COVID crisis. And that included the following: effective enjoyment of all these rights and freedoms guaranteed by Articles 8, 9, 10, and 11 of the Convention is a benchmark of modern democratic societies. While heightened restrictions to these rights may lawfully be justified in time of crisis, harsh criminal sanctions give rise to concern and must be subject to strict scrutiny. Similar words were enunciated by the United States Commission on International Religious Freedom, who offered the following guidance: it is important for governments to account for religious freedom concerns in their response to COVID-19 for reasons of both legality and policy effectiveness. From a legal perspective, international law requires governments to preserve individual human rights, including religious freedom, when taking measures to protect public health, even in times of crisis. From an efficacy perspective, considering religious freedom concerns can help build trust between governments and religious groups, who in the past public health crises have played a critical role in delivering health intervention. Now, each nation will, of course, have its own means for the exercise of emergency powers, and to the extent that there may have been governmental overreach, that will be a matter for the courts of that country to determine. As a general rule, the more imminent and severe the risk to the public, the more likely that restrictions will be adjudged necessary and reasonable. But as the pandemic continues, greater scrutiny will be given to issues of constitutionality. The deference which is afforded by the governed to those who govern will depend upon the perceived competence of the government and the extent to which it carries the trust of the people. There is a steady stream of cases from around the world, now developing into something of a torrent, in which the constitutionality of emergency provisions has been challenged. In Katumba and the president of Malawi, the High Court of Malawi determined that the country's public health regulations were ultra vires their parent legislation, which was condemned as, quote, very old and ill-equipped to deal with a pandemic of the COVID-19 magnitude. The Kenyan case of ex parte Langat which concerned a health emergency in 2017 arising from shisha use and communicable diseases, identified what it called a precautionary principle, which allows, indeed compels, the state to take protective measures without having to wait until the reality and seriousness of the risk are fully demonstrated or manifested. This precautionary principle was applied in the Law Society of Kenya and Matiumbai, where the imposition of a night curfew was considered to have been sufficiently justified by the perceived danger. In the Katumba case, the High Court of Malawi offered very helpful advice and guidance as to matters which should be considered and addressed by government prior to the imposition of future lockdown measures. Now, a procedural decision taken in the Supreme Court of Victoria in Australia raised an interesting point about the evidence which a court would expect to see when assessing the validity of emergency regulation. The defendant in that case was the Deputy Public Health Commander for the City of Melbourne. She issued stay-at-home directions, imposing, as their title implies, a curfew. The plaintiff contended that the directions violated her rights under the Charter of Human Rights and Responsibilities Act in force in Australia. The defendant led evidence that in deciding to make the directions, she had received legal advice that the directions were compatible with that charter. But the advice was redacted and legal professional privilege was raised. The judge determined that the advice was disclosable in full. How can a court make a proportionality assessment unless the government produces adequate expert evidence of the genuine risk to public health of the pandemic and of a proper and informed consideration of the impact of any restriction on the civic rights of citizens? Now, I do not propose to say anything at this stage about the detailed lockdown provisions that were introduced in the United Kingdom, their progressive easing, and more recently, their gradual reintroduction. For those wanting to know about this high-octane corona coaster, it is fully referenced in my paper, together with links to commentators who have reported the highly complex and mutually contradictory regulations which change almost daily. But what of the reaction of religious organizations? Most of them have issued their own guidance, either nationally or locally. The British Board of Scholars and Imams, for example, in a briefing document, offered the following guidance. We take seriously our responsibility to minister to the welfare of the community, both worldly and next worldly. This involves a recognition of the serious importance that our religion places on life, health, community, and spiritual well-being. To trivialize any aspect of this would be an error. As our scholarly tradition demands, our approach in the guidance is directed by consideration of what is essential, recommended, and desirable. This includes a keen understanding of when and which religious rulings may be suspended due to temporary harm or hardship. And this is illustrative of an approach which was common across the wide range of religious organizations, suggestive of a willing and voluntary surrender of certain aspects of religious liberty in pursuit of the common good. Within the Jewish community, for example, the chief rabbi counseled extreme caution in reopening synagogues, arguing that the overriding guiding principle for a return to normality had to be the sanctity of human life. He went so far as to suggest that the Jewish community may need, in some respects, to hold back for a time even if guidance would permit going further. Indeed, we may have a religious obligation to do so, he said. And circumcision organizations have directed that attendance be restricted to the parents of the baby concerned and the officiant. Some decided even to suspend circumcisions altogether during the period of the pandemic. Such a difficult decision, they said, has not been made lightly, but we believe it is in keeping with the overriding Jewish value of preserving life. And it wasn't only Jewish and Muslim leaders who showed self-restraint, going further than the restrictions imposed by the civic authorities. Controversially, perhaps, the Church of England instructed its clergy not to enter churches, even to live stream liturgy, notwithstanding that this was permitted under the health protection regulations then current. Even at the height of lockdown, attendance at places of worship was permissible to broadcast an act of worship, whether over the internet or as part of a radio or television broadcast. Anglican priests were instructed not to do so, although subsequently church authorities sought to clarify that this was merely advice, albeit strongly worded. And somewhat anomalously, therefore, the great feast of Easter was marked by a televised service in which the Archbishop of Canterbury celebrated the Eucharist, not in the sacred space of the historic chapel at Lambeth Palace, but in the ultra-modern kitchen of his private flat, with a Kenwood chef on his makeshift altar. But what about the British cases? What about those cases which have been brought to the court so far? The first in time is that of Hussein and the Secretary of State for Health, and that concerned the closure of places of worship. The judge, Mr. Justice Swift, refused an application for interim relief concerning a mosque in Bradford. The applicant sought an order suspending the enforcement of the regulations so that the group of Muslims could attend Friday prayers, observing, as appropriate, the social distancing requirements. It was argued that the failure to make provision for the claimant to attend the mosque for Friday prayers was contrary to his right under Article 9 of the European Convention to manifest his religious belief in worship, teaching, practice, and observance. And the judge adopted broadly the Strasbourg methodology, which I outlined at the beginning of this paper. There was no dispute that the regulations did indeed violate the claimant's right to manifest his religious belief. But the judge concluded that the interference with that Article 9 right was justified. It only inhibited one aspect of the claimant's religious observance, albeit a significant one. The duration of the infringement would be for a limited time, albeit unfortunately, it was then occurring during the season of Ramadan. The government had published a strategy document with a route map to lifting the restrictions as and when it was safe to do so, and doing so in consultation with the places of worship task force established expressly for this purpose. A further point was that the British Board of Scholars and Imams had expressed a view which was less extreme than that being advanced by the claimant. The judge regarded the pandemic as, quote, truly exceptional, such that the interference would be justified on grounds of health. He continued, the virus is a genuine and present danger to the health and well-being of the general population. I fully accept that the maintenance of public health is a very important objective pursued in the public interest. The Secretary of State describes the basic principle underlying the restrictions as being to reduce the degree to which people gather and mix with others not of the same household, and in particular, reducing and preventing such mixing in indoor spaces. I accept that this is the premise of the restrictions in the regulations, and I accept that the premise is rationally connected to the objective of protecting public health. It rests, he said, on scientific advice acted on by the Secretary of State to the effect that the COVID virus is highly contagious and particularly easily spread in gatherings of people indoors, including in mosques, churches, synagogues, temples, and so on, for communal prayer. Now note that the outcome in that British case differed from a German constitutional court decision in the case of F, decided in April of this year, which also concerned Friday prayers. The key distinction was that the German constitutional court concluded that a general prohibition of public worship was in breach of a particular article of the German constitution, since the law did not allow for exceptional approval to be granted for religious services on a case-by-case basis. In another British case, Dolan and Marks versus the Secretary of State for Health, a wide-ranging application for judicial review was refused. The judge adjourned consideration of the alleged breach of Article 9 as the easing of the regulations with regard to communal worship was already in train. The claimant asserted that the prohibition on the use of places of worship involved a breach of Article 9 because, as a Roman Catholic, he had not been able to attend worship or receive the sacraments. Following the hearing, but just before judgment had been handed down, the regulations were eased, permitting acts of communal worship for up to 30 people. The judge remarked that in relation to the Article 9 breach, quote, "This aspect of the claim may have become academic." Now, don't you just love it, the way some judges delight in deploying the expression academic as if it were a pejorative term of abuse? Because don't forget this, in an evolving pandemic, an unscrupulous government, if you can visualize such a thing, might revoke impugned regulations just prior to judicial scrutiny, thereby rendering a court powerless to strike them down. Well, the High Court of Malawi was astute to such questionable practice. And in the case of Katumba, which I've already mentioned, the court observed this. Ordinarily, the extinction of the subject matter to litigation has the consequence of extinguishing the entire cause of action, rendering any decision-making by the court moot, thereby becoming a mere academic exercise and of no legal consequence. However, subject matter extinction must arise out of an uncontrollable or inevitable event that occurs during the course of proceedings. Subject matter extinction cannot be conduced by any of the parties to the matter. A finding that the matter herein is moot would only enable the government to evade review of a matter capable of repetition. The facts of the present case are therefore not caught by the constitutional doctrine of mootness. So how often, I conjecture, in the months ahead, will common law judges throughout the world be confronted by slippery governments seeking to evade scrutiny of regulations which give rise to serious human rights violations, but which are capable of reenactment as the coronavirus continues to live with us? Well, turning our eyes across the Atlantic and to the USA, there are two cases, as far as I am aware, that have so far reached the Supreme Court of the United States. And on each occasion, the court has ruled against the church, which was seeking exemption from statewide closure of places of worship during the COVID-19 pandemic. And as the Supreme Court of the United States has received so little media attention in recent weeks, I shall say just a few words about those decisions. The general rule in religion cases is that people of faith are bound by valid and neutral laws of general applicability. They cannot claim special exemptions from laws that apply to everybody, but the government may single out religious organizations for inferior treatment or place burdens upon them. The South Bay United Pentecostal Church and Newsom concerned an allegation that coronavirus regulations in California treated churches less favorably than similar secular institutions. By the time the case reached the Supreme Court, retail businesses and many workplaces had reopened, albeit with restrictions. Chief Justice Roberts observed the following: although California's guidelines place restrictions on places of worship, those restrictions appear consistent with the free exercise clause of the First Amendment. Similar or more severe restrictions apply to comparable secular gatherings, including lectures, concerts, movie showings, spectator sports, and theatrical performances. Where large groups of people gather in close proximity for extended periods of time, and the order exempts or treats them more leniently, only dissimilar activities, such as operating grocery stores, banks, and laundromats, in which people neither congregate in large groups nor remain in close proximity for extended periods. The decision was that California's public health order did not require any additional accommodations at that stage for places of worship. It was sufficiently compliant with free exercise provisions. And as to the general approach in the exercise of judicial discretion, Chief Justice Roberts said, the precise question of when restrictions on particular social activities should be lifted during the pandemic is a dynamic and fact-intensive matter subject to reasonable disagreement. When officials act in areas fraught with medical and scientific uncertainties, their latitude must be especially broad, and provided those broad limits are not exceeded, local officials should not be subject to second guessing by unelected judges who lack the background, competence, and expertise to assess public health. This is especially the case where a party seeks emergency relief while the competent authority is actively shaping their response to changing facts on the ground. And a substantive dissenting opinion from Justice Kavanaugh in that case is worthy of consideration, but I note my time is passing rather more swiftly. The second case, more briefly, Calvary Chapel, Dayton Valley, and Sisolak, concerned a Nevada public health order directing that churches may not admit more than 50 people at any one time, whereas casinos, breweries, bowling alleys, and gyms could operate at 50% capacity, a capacity which could be really somewhat large. Same points were ventilated, and the same points were made by way of dissent. And I draw your attention not only to a second dissent by Justice Kavanaugh, but a very powerful assent by Justice Alito as well. It's not all negative. The wonderful term "covidential" has been put to use, dealing with certain positive advantages that have come out of this crisis. My paper has focused on the curtailment of freedom of religion, real or perceived, in consequence of governmental responses to the COVID emergency. It's a helpful counterbalance to identify certain unintended benefits which have accrued in a manner I refer to as confidential. Imaginative new ways have been found to allow religious organizations to flourish and tend to the spiritual needs of congregations. Religions have become more accustomed to the use of modern technology, and the state has been compelled to enter into a meaningful dialogue with religious organizations. A lasting effect of the emergency is an improved and enduring dialogue between religious organizations and regional and local governments. This will have huge effects in the future. An enhanced level of religious literacy will lead to improved understanding within government of the beliefs and practices of faith communities. So to conclude very briefly, it is difficult to postulate firm conclusions in respect of a situation which is still evolving. This paper is a work in progress, something to which I will return doubtless in the weeks, months, and dare I say years ahead. With hindsight, matters will be viewed somewhat differently. But that's not a reason for resisting conjecture while still in the eye of the pandemic, as we are now. And I just table for discussion some thoughts and some reflections, mindful that they are all, of course, capable of improvement, refinement, and augmentation. Navigating a global health emergency requires a high level of trust between the government and the governed. The greater and more immediate the threat, the more likely the population generally will tolerate restrictions on their human rights in general and the curtailment of religious liberty in particular. Public health emergencies must be handled within the framework of the rule of law. Collaboration between the state and religious organizations, which is desirable in ordinary circumstances, becomes essential during a health emergency. Any curtailment of religious liberty, as with civil rights generally, should be the minimum possible consistent with the emergency faced. Restrictions need to be focused and time limited. Lesser means of achieving the same aim should be considered and rejected. And I suspect, having reviewed a number of cases from around the world, that judicial deference will wane as time goes by and expectations of government will increase. This paper is not the final word on the subject. Academic papers very rarely are. But I hope it has provided an overview of the current issues and the vibrant way in which they are being faced throughout the world by governments, by citizens, and by the judiciary. It is the beginning of a conversation which will stretch long into the future. Thank you very much.
Thank you very much, Professor Hill. And now we'll hear from Professor Arif Jamal, please.
Thank you. Let me begin by expressing my thanks to all of the organizers, and particularly to Notre Dame Law School, for the invitation to participate in this webinar. My brief, as I understand it, was to speak a little bit about Asia. It is difficult to speak about Asia in one breath due to its size, diversity, and complexity. So in the interest of time, I'm going to try to speak with some generalities. That said, I'm based in Singapore, so while I'm going to try to speak from an Asia perspective, I do so from a Singaporean or Singapore-based point of view. I hasten to say this because of the observation that where you stand on an issue might depend a great deal on where you sit, and I am sitting in Singapore. There were several themes in Professor Hill's paper which resonated, but I'd like to come to the end and try and bring those, at the end of my comments, and bring those together. Let me start by laying out three factors which I think are impacting and affecting how we are dealing with the issues of religious liberty and its curtailments in Asia at the moment. The first is what I would call an ethos. And this ethos might emphasize, not surprisingly perhaps to many of you, the notion of a more communitarian social and political ethic that is running widely in Asian context. So therefore, a somewhat lesser emphasis, not an absence, but a somewhat lesser emphasis on individual rights, individual claims versus a community outlook. The second point is about power, or indeed the power of governance. And here I want to emphasize the capacity in jurisdictions across Asia for governments to regulate, control, or even capture religious organizations, religious institutions, and the powers that they have more generally outside of pandemic times to do these when compared perhaps to other parts of the world. And the last point is a question, is a point that tries to bring these two together, the question of ethos and governmental power. And I might call it a governmental type culture. And it is one that which I see as being defined significantly by collaboration. Now, I don't mean collaboration necessarily in the negative sense. A collaborator is not a positive term. Collaboration, however, need not be negative. And this collaboration has seen some of the things that Professor Hill is talking about being manifested in Asia. So let me give you some examples. Professor Hill mentioned the work of the British Board of Scholars and Imams, and alluded to the type of self-restraint that is being shown across a number of religious communities and organizations based on a religious justification. That is something which one has seen in Singapore as well, whether it is with the suspension of masses in the Catholic Church and the move to online sort of television-based service. Similarly with the Muslim community and the Islamic Religious Council of Singapore, which has worked with the government in restrictions on mosque attendance and had to deal with the issue of Ramadan and the celebration of the Eids. And again, has also moved to using new technologies like television channels to engage the community. And with Diwali, or Deepavali as it's known here, coming up, the Hindu communities as well, having to adapt the types of ways in which they would commemorate this important festival of lights by asking the community, for example, to observe street lighting that took place in a socially distant way and then to watch it on television. So that brings the idea that in fact the modern technology, the use of modern technology that Professor Hill talked about is something one also sees in Asia. And the importance of dialogue, a dialogue which is engaging within this communitarian ethos, the religious communities. Now, having said all of that, let me just say, to go back to the earliest point I made, that Asia is vast and diverse, and therefore there are different things happening in different contexts. Just earlier today, the BBC reported that religious leaders in Nepal are warning that God may punish Nepal for canceling rights and religious services. The religious leaders are warning the government that God may punish the country, particularly when you consider these important events which are about to come. Nepal is a majority Hindu country, as many of you will know. So to end, I think that there might be a different sort of, broadly speaking, ethos, which is manifesting, and a sense of power, which is manifesting into a different cultural frame measure. But I can see a lot of resonances with what Professor Hill was talking about happening in Europe and in the United States. Thank you.
Professor Jamal, thank you very much. And we'll now hear from our third speaker, Professor Idowu Akinloye.
Hello. Greetings from Southwest Nigeria. I thank the organizers for inviting me to speak on this platform. And it's also a great pleasure to be in the midst of distinguished scholars of law and religion. Professor Hill, thank you for laying a solid foundation for my presentation, because a lot of thoughts from his paper resonates with the happenings currently in Africa. My paper reviews the curtailment of religious liberty in Africa in the wake of coronavirus pandemic. It focuses on how religious institutions and their leaders have responded or are responding to the various regulations and measures that restrict religious freedom during the pandemic. Like other continents, Africa is not immune to coronavirus. And to stem the spread of the virus, various states came up with emergency measures and regulations, such as those that impose restrictions on large gatherings, including religious gatherings, and closure of worship places, with attendant sanctions for their violations. Some of these measures no doubt violate rights like the freedom to assemble and to worship in public. However, despite the widely held view of African peculiar religiosity, it was surprising that most religious leaders supported the restrictions of religious liberty at the outset of the outbreak of the pandemic. The basis for this initial acceptance is unclear, but perhaps it can be predicated on three possible formulations. The first is the acknowledgement that the medical facilities of virtually every African state are poor and grossly inadequate. Accordingly, the restrictions will allow time for governments to build up a formidable public health response. The second is that the religious leaders perhaps are convinced that every state has the constitutional duty to protect the life and health of citizens. And thirdly, the restrictions are mostly short-term. Hence, they are temporary measures to achieve a greater good of saving lives, including the lives of the religious adherents as well as the religious leaders. But as the restrictions persist, perhaps beyond the time anticipated by the religious leaders, some religious actors began to contest the legitimacy and the constitutionality of the lockdown regulations. Some religious actors also feel threatened that the prolonged ban are attempts by the secular powers to regulate their religious activities. Basically, religious bodies in countries like Nigeria and Muslims-dominated North African countries did not challenge the restrictions in court. They merely expressed their displeasure in the media. However, in some other countries, mostly from Southern Africa, like Namibia, Malawi, and South Africa, we have some litigants that sought court orders challenging the constitutionality and legitimacy of restrictions on religious activities. I will briefly use South Africa as a reference because that is a country where we have a lot of litigations regarding this issue. In South Africa, although the decisions of the courts are not consistent, a review of the majority of the court rulings illustrates a judicial perspective that though the ban on religious activities is human rights deficit, it is reasonably and constitutionally justifiable in a democratic society, given the health threat that the pandemic poses. For instance, in the case of Mohammed and the President of the Republic of South Africa, the court held that the restrictions were neither unreasonable nor unjustifiable on the basis that the ban was not selective, discriminatory, or against a particular religion. It was further held that the pandemic calls for every citizen, in the name of humanity towards others, to make sacrifices to their fundamental rights. But a contrary conclusion was reached by the court in the Beer versus the Ministers of Cooperative Governance and Traditional Affairs. In that case, the court, adopting a rationality model, considered as discriminatory, irrational, and unconstitutional the lockdown regulations that provide for a blanket ban on religious gatherings, but allows up to 50 members at a funeral and a number of passengers in a taxi. This principle in Dibia appears to represent the popular approach adopted in most of the other countries like Namibia and Malawi. Professor Mark has said a lot about Malawi. For instance, a high court in Malawi held that lockdown regulations cannot be arbitrarily enacted. It must be authorized in terms of the law and constitution to earn legitimacy. The court further emphasized the power of the courts to inquire into the legality of the measures taken by the states in response to an emergency or disaster. But before I conclude, let me also raise an issue that is prevalent in some African countries, and that's what I've categorized as politicization of religion or the religiousization of politics. A situation in Nigeria, for instance, that we have instances where political actors, such as the elected governors of federation states, were seeking and clamoring for the reopening of religious places during the peak of the pandemic. The attempt which some religious leaders rejected. So the only possible formulation for this attempt by the political actors is what I have illustrated as the politicization of religion and the religiousization of politics, whereby some African political leaders, like those ones that I've mentioned above, use religion as a tool to score political points and woo religious adherents to legitimize their political advances. However, as I conclude, I wish to submit that these cases that challenge the legitimacy and constitutionality of lockdown regulations in Africa raise some important issues and positive outcomes. First, they reinforce the assertion that freedom of religion is one of the most sensitive and controversial of all human rights and a potent source of social conflicts. They also reveal some vacuum in the extant legislation that deal with the management of pandemic in most countries, which perhaps had not been subject of courts or public scrutiny prior to the outbreak of this pandemic. The lawsuits are also a signal to the government that citizens could go to court to challenge the limitations of their rights or seek clarity on the rationale behind the lockdown regulations and their constitutionality. Accordingly, in the exercise of public power or performance of a public function, there is the need for state apparatus to self-scrutinize in order to ensure the legality and constitutional compliance thereof. This is what Justice Correll of Kenya High Court says in the Law Society of Kenya and Hilary Mutambi. He says, it is necessary for defenders and upholders of the rule of law to be extra vigilant whenever the state exercises emergency powers. Thank you. Thank you.
Okay. Thank you to the panelists. That was a really wonderful presentation. I'm going to take a few questions that have been coming in from the audience, and I'll just remind audience members to go ahead and use the Q&A function to keep sending in your questions, and we will go through them as we have time. I think this event is scheduled to end at 12:30. So the first question I'll start with, this can be a question to all the panelists, but let's start with Mark. The student says, first of all, thank you for the presentation. And then he points out that in many countries, there have been extensive curfew or lockdown orders, but they carved out exceptions for essential services. So religious services, whether congregational worship, deathbed rites, or Bible study groups, often didn't count as essential, but a lot of other things did. So a couple questions about this. Does this undermine the important value of religious freedom when this sort of value judgment about religion by policymakers treats these as not essential, this sort of spiritual therapy, when other things like retail therapy might be essential? And how should the law think about treating religion different, maybe giving it less protection? How should we think about this under international law? And also specific here with some of the cases that you discussed, Mark, at the Supreme Court as well. So I'll go ahead and turn that over, starting with you, Mark, and then if other panelists want to jump in, that'd be great.
Well, I think I'd like to begin answering that by expressing a very sincere note of sympathy with governments. They didn't ask for this pandemic. They haven't made policies to deal with it. They are responding on the hoof, doing the best they can in an ever-changing world. So it's hardly surprising that people, for various reasons, criticize the nature and content of individual parts of regulations. But again, the longer it goes on, the higher our expectations of government that they will regulate in an appropriate way. And I commented, I think, in my closing remarks about the historic illiteracy of government in the language of religion. Let me give you some examples. That in our British regulations, a constant theme is the venue manager. Now, most parish priests see themselves as exercising a sacred ministry, but because of the very secular way that legislation is drafted, they become venue managers. And then the blessed elements of the Eucharist, well, that's referred to as consumables. So as governments try to find the language they need, religions need to help them to do so. It's very much a two-way street. And the government isn't using that language pejoratively. The government simply doesn't know the language which it should use. Now, I think the questioner has alighted upon a really serious concern, and that is the stage at which the government is forced to make a value judgment. And the example the questioner gives of the term essential service. Who is to judge what is essential? From the point of view of the individual believer or the institutional church, what is essential may be very different from the view seen by either a very secular government or a more pluralist government which doesn't differentiate between shades and complexions within the religious community. As a matter of general law, as a matter of well-established international principle, it is not the function of government to adjudicate on the authenticity of religion and to be the arbiter of what is essential and what isn't. And so it's quite clear that there needs to be pushback so far as that is concerned. But I think we are very much on a trajectory And I think it was perfectly acceptable for the government to be overly restrictive at the outset and to make swift judgments which were harmful to religious believers, because the danger was immediate and the danger was great. But we're now 7 months in, and that position is changing. And the government needs to draw back and needs to trust religious organizations to make those decisions for themselves as to what is essential and what isn't, and to balance very carefully where risk falls and where religious freedom abuts against that level of risk. The government cannot allow vast meetings in huge church gatherings, which are just a hotbed for breeding the virus. But it needs to be more careful to use language and to listen and to be receptive, so that as time goes by, the regulation is more light touch and less oppressive.
I wonder if I can just add a little bit to what Mark has just said, largely in agreement with the perspective he has articulated, but to illustrate this through a couple of things that happened in Asia. As Mark said, nobody, certainly governments, didn't want this sort of pandemic. It has caused a big strain on the fiscal purse, as well as having them have to make some challenging policy decisions across a whole area, a whole range of areas of law on the hoof. But I think one of the things that one noticed was that particular forms of congregational religious practice were becoming some of these hotspots. We saw this in Asia, in South Korea. There were gatherings in churches that became sort of big spreader events. Similarly, in Malaysia, in a sort of gathering of Muslim communities there. And therefore, there was, I think, a recognition early on, when we were still coming to understand the pathology of the virus, that closed spaces, activities that might involve singing or other vocalization, and close contact for an extended period of time, some of the things that were part and parcel of congregational religious practice were becoming especially dangerous in terms of being modes of transmitting, vectors of transmitting the virus. And this was recognized, I think, by the religious communities themselves. And they understood that, they responded to that. Of course, differently in different places. Again, sitting in Singapore, I can say that this was well understood before the government ordered it or would have ordered it. The Catholic Church, for example, in Singapore said, we are going to suspend physical masses. And the Islamic Religious Council, did the same with restrictions on prayer, and particularly, as I mentioned earlier, at the time of the Eid. So I think there was a recognition that certain forms, particularly of congregational religious practice, were a real problem, and the religious communities recognized that and worked with government a little bit.
Professor Akinloye, did you want to add to that at all?
Oh, Professor Akinloye, you're muted.
Okay, thank you for the question. Just like what others have said, issue of religion, I think, is more peculiar important as far as African is concerned, because basically virtually all Africans are very religious. I think a lot of research has confirmed that. And before the political actors and political powers, we impose any regulation that will be generally accepted if it openly contravenes the religious beliefs and tenets of the people. It may not receive popular support of the populace. So I think it is necessary for government and for states to engage in discussions and negotiations with religious organizations, and to see how they can collaborate together and come up with regulations that will not greatly impact on the religious liberty of the populace. I think with this, there will be a form of equilibrium and agreement point between the religious institutions and political decisions. Thank you.
That's great. Thank you all. I want to follow up on one thing you were talking about, Mark, which is also relevant to the question you touched on from our panelist, Christopher. But you mentioned that as the pandemic continues, there is an expectation that it will be more difficult for the state to justify some of its more restrictive measures. At least that's what I thought that you were saying. So I want to see if the other panelists agree with that, number one. But Mark, let me start with you and ask, it sounds like you're saying it's normatively desirable for the government to move in this direction of having more of a light touch, as you say. But is there a role for courts to enforce that? What should be the test? Because perhaps I'm a little less sympathetic of government officials than you are. I mean, I do think that they have a hard job, but on the other hand, are we just going to leave that up to their goodwill, or are there going to be external sorts of protections or standards to ensure that inappropriate value judgments just about the use of religion in general aren't being made in ways that create double standards?
Well, I think that's a very interesting question, both the one raised by Christopher Grout on the Q&A and your supplement to that. And we go back to the point that we are on a continuum. What's right today may well not be right tomorrow. And had time allowed me to delve more deeply into what was said in the powerful dissents in the US Supreme Court, the question of deference to local officials is very much still in play. And one allows deference when the answers are unclear and there's a wide range of discretion within which those officials can operate. It's not unlike the principle of margin of appreciation. A high-level decision maker quite rightly defers to a lower-level decision maker who has the information and knows what's going on. And to the extent to which there are straws in the wind, I don't think either the US Supreme Court or British courts or courts throughout the world are going to continue to cut the slack that they have done to governments hitherto as this progresses. And we see indications globally as to why we are heading in that direction. It's very rare in a paper for someone to cite an interlocutory procedural decision of a court in the southern part of Australia. But that decision in Melbourne, I think, is highly significant. The judge compelled these public officials to put before the court the full legal advice, the full legal assessment that the Melbourne city authorities had made as to whether each and every item of their proposed lockdown regulations were compliant with the Human Rights Charter then current. So in other words, the Australian courts, or at least those of the province of Victoria, are not going to take at face value mere assertions by government officials that their in-house legal advice is that these regulations are human rights compliant. They are going to call upon those state officials to disclose the advice so it can be read and studied by the applicants' lawyers, and studied in detail and at some depth by the judges themselves. But there's a second aspect to this. It's not merely pushing back and determining the extent to which proposed regulations are human rights compliant. It's looking at the scientific evidence itself. Again, in the early stages of the pandemic, not a huge amount was known. One accepted that a few highly experienced experts would give an opinion that would often carry the day. Well, that day is gone. Where we are now is in a much more aggressive area where scientific evidence will be interrogated, and judges will expect the government to lay before the courts, when they seek to justify their regulations, detailed scientific evidence as to why the regulation is being imposed and to why any less onerous provision is deemed to be inappropriate. And that evidence can be properly interrogated by the judiciary, by having counsel ask questions and push back, and not accept mere assertions at face value. The first of the British cases I cited, the case dealt with by Mr. Justice Swift at first instance, is under appeal. Forgive me, it may be Mr. Justice Lewis, the second one, but an appeal was heard last week. And I don't think for one moment the Court of Appeal, in hearing that appeal, will give such an easy ride as was given first time out, because it was in such a pressing position of a huge level of urgency and emergency. So, yeah, I'm sympathetic to local officials, but only so far. They have got to justify every decision they make. And now that they're making decisions in a less pressured environment, the need for justification and the evidential premise on which the justification is made, a far higher standard will be expected of them by the judiciary.
May I just add a little perspective to that? So in Asia, like Idowu was saying, North Africa, Asia also has fairly high degrees of religiosity compared to other parts of the world. Europe, perhaps vis-a-vis Europe, and perhaps vis-a-vis even the United States, and quite high levels of religious diversity in many places. In fact, a Pew study a few years ago found that Singapore had the highest religious diversity in the world. For that reason, I don't think that governments are going to take religions, and it's important to talk about that in the plural, lightly. Even those governments that are sometimes express hostility to certain religious traditions, and you see this happening in India, in Sri Lanka, in Myanmar, and these sorts of environments, but they recognize the force of it. And therefore, I think to your question about, the longer this continues, is it going to be harder to enforce? I think the answer is, well, yes, it will be, but the mechanism to resolve it or to have these conversations, I don't know if it will go as much to court. It might in some jurisdictions like India and other places. In others, it might be done more on a dialogue basis.
Thank you, that's very helpful. There's another question that has come in for Dr. Akinloye. I hope I'm saying your last name right, Doctor. The question is, what measures did the Nigerian religious organization take to assist the government health sector? And you are still muted.
Yeah, thank you for that question. The introduction of my paper, I indicated that the religious organizations and religious leaders tolerated the restrictions, and I was wondering why will they do that? But not only that, they could see practical instances of steps that the religious institutions all take to support the government in the bid to control the coronavirus pandemic. For instance, the Catholic missions in Nigeria were willing to offer over 200 hospitals to the government to be used as isolation centers for those people infected with coronavirus. Then we've seen instances whereby a particular church denomination gave facilities worth over 1 billion Nigerian naira. That is over 3 million US dollars that a particular religious organization gave to support the government to curtail the spread and to contain the spread of the virus. So I believe the religious organizations, they have contributed their parts towards the curtailment. And this also is significant to the point I've made earlier, that religion is a strong force as far as Nigeria is concerned. And that is why the government cannot take with levity issues that affect religious organizations when it comes to Africa and perhaps other continents, just as Professor Arif just said. So I think it is important, as I've said before, that religious political leaders engage and discuss with religious organizations to be able to manage the issues that affect them and affect their adherents. Thank you.
I think that's a really interesting point, Dr. Akinloye, as far as a lot of the media attention has focused on ways in which public health and religious exercise in the pandemic has been in conflict. But I'm interested if other panelists also have thoughts about ways in which religious groups have actually worked to help the government or have been able to, assist accessing vulnerable members of the community or leverage some of their networks to try and be supportive of things that government was doing in the global pandemic. So are there other sorts of positive sides of this story and partnerships that maybe we're not hearing about as much in the media that any of the panelists have other additional thoughts about?
Well, maybe I could just come in first, simply to agree. I mean, there are enormous examples, and this isn't just in the less developed world. I mean, one sees here within yards of where I live that it's church communities that are providing food banks and reaching out to those who are self-isolating and so on. So the role the churches collectively are performing is immense, and lots of church buildings and their ancillary buildings that were closed at the height of the pandemic for worship adapted to be used for the relief of hunger and in other ways for taking in the homeless as accommodation and so on. There's a huge amount that religious organizations are doing. And I think that all feeds back into the general point of dialogue that provided the government, and I have to be honest, I think this is much more a local than a national thing. It's within towns and cities where local administration and local religious leaders know one another better and have the capacity to move swiftly and to deal with these matters, where there can be a really high level of cooperation, and where religious organizations can be seen as being an essential tool at the disposal of the government in order to deal with these presenting issues. So I think the less one sees it in polarized terms with the government and with religious organizations, as it were, so far apart they'll never meet. In fact, their interests not only come together, they often overlap, and sensitively approached, they can be harnessed to the mutual advantage of both.
Yeah, I want to agree with that, because we've seen instances here, well, the instances in different parts of the world. I did see a report about a Sikh community, for example, where they would have a tradition in preparing in the Gurudwara a communal meal, which others could take. And what this community did said, since we're not gathering in the Gurudwara, they still cooked the meal. And this was in the UK. And then they delivered these meals to frontline health workers in British hospitals, etc. There are other ways in which the religious communities are reaching out through their community networks to contact the vulnerable, to do shopping for people, to call people who might be living alone, so that they don't feel so isolated. There are a lot of things that are being done that are helping the governments, not necessarily because they want to be helping the government, but because they're doing this out of their own convictions and traditions. But it is serving this important these important social purposes and policy purposes.
Professor Akinloye, anything else to add to that? I know you already spoke about that briefly, so no problem if not.
Okay, if you don't mind, if I can just add a little to what I've just said before.
Yeah.
Okay. Yeah, I think another important way the religious organizations can contribute to this issue on ground is the issue of how to assist in passing the information across to the religious adherents and the populace. It is generally believed that majority of religious adherents and followers believe in their religious leaders more than even the political leaders as far as African context is concerned. So now I believe that the religious leaders, if they are used to pass the necessary information across to their followers, it will go a long way to help in even taking appropriate steps to curtail the spread of the virus. Basically, in Africa, there are still some groups that still believe that coronavirus is not real. There are some that still believe that it's a scam, that the political actors are just using the means to corrupt themselves to secure funds. But I believe if their religious leaders are the ones speaking to them that this is real, avoid this, avoid that, they will listen more. Because in Africa, you see people saying, okay, my religious leader said, my pastor said, my imam said, as against that my president said, as against my governor said. So I believe it will be very useful for political leaders to engage with the religious leaders to see how they can help pass information across to their adherents. I believe that will yield a faster and a speedy way of passing the information across to the followers, and we make things to work better.
Yeah, these are great points about credibility religious leaders have to encourage groups to take precautions and ways in which they can access different networks. Okay, I'm mindful that we only have about 5 minutes left, so I'm going to combine two of the final questions in the Q&A, and our audience has been doing a great job sending in these questions. So Roger asks, and this will be a question for all the panelists, the ability of governments to shut down religious observance so easily and for so long seems to create a dangerous precedent that can smack of anti-religious secularism. It seems to drive religion out of the public square. How can we ensure it is difficult for this to happen too easily again? And sort of in a similar theme, Bright asks, is it possible for states to do better at attempting to facilitate an overlapping consensus about what is best for some citizens and to make the restrictions more palatable? So I will turn this over to our panelists. What if we start with Professor Jamal, and then we'll go to Professor Akinloye if he has any comments, and then Professor Hill will let you have the final word.
Thank you, and thank you to the participants for these questions. To Professor Trigg's question, sitting where I'm sitting now in the Asian context, I don't see the same risk that perhaps might occur in other contexts of religion being driven out of the public sphere, or the public square, that his question is pointing to, because of the levels of religiosity, and because also it seems still to be very much discussed, very much highlighted. So for example, and again, I caution, I caveat this always by saying Asia is very big, so I can't speak about all of it, but the recognition of some of the festivals and things, the government support for these things, like Diwali that's about to happen, you can see this being expressed publicly. And so, so in Singapore, for instance, the Deputy Prime Minister was attending an event broadcast on the news where they were lighting the Diwali lights in an area of the city called Little India, which is traditionally where they would light these Diwali street lights. And so I still see it very much in the public sphere, though I take Professor Trigg's question seriously. On the other question about the overlapping consensus, I don't know, I've always found the idea of overlapping consensus attractive, but the achievement of it tends to be very difficult. And so, one can hope that greater dialogue and communication will result in overlapping consensus, but that is, that's more aspirational, I think, than, easily realizable.
Great, thank you. Professor Akinloye, anything to add?
Okay, let me also say that from the African context, it may quite be difficult to drive away religion from the public space, because I've said that as far as African is concerned, even the religious leaders, the political leaders, a lot of them are also religious. For instance, let me take Tanzania for instance. The president of Tanzania did not make any declaration or any regulation regarding closure of religious places. In his words, he says that coronavirus cannot overcome or cannot enter into the body of a faithful. And that is to show how some religious and political leaders themselves are very, very religious. So I believe it will be very, very difficult for a religion to be taken away from the public space as far as African is concerned. In fact, that is one of the reasons why we have some number of litigations, because some religious leaders believe that the prolonged ban is an attempt from the political space to encroach or to control the affairs of religious activities. I believe religious organizations may not really entertain that.
Okay, great, and we are just about out of time, but Professor Hill, if you have just maybe 30 seconds worth of wrap-up thoughts, we'd love to hear them before we close.
On the first question, that overlapping consensus is all well and good, and what is best. But again, it's not for the government to decide what is best for religious organizations. Those are value judgments which only properly religious organizations can get. So that argument goes so far, but it doesn't quite go all the way. The joy about these virtual engagements is that one catches up with old friends, and it's lovely to hear from Roger Trigg. Roger, you and I will never entirely agree on the place of religion in the public square. I always see more of it than you do. You're more fearful than I am that it's washed away. I'm going to make two observations, if I may. The first is, I think your concern is based in part about the complicit nature of religious organizations in agreeing with government to the restrictions in the first place. And I think it's unlikely to happen again, because religious organizations will be less complicit when a second wave comes through and when further regulations are talked about. I think many religious groups regretted that they went so far to assist the government in such an oppressive form of lockdown. They will be less complicit in future. And in addition to that, there are certainly in Britain now a highly animated cadre of highly experienced, worked up human rights lawyers. and they ain't going to let it happen a second time.
Thank you, Mark. Thanks to all of our participants. Thanks to all of you who joined us on this webinar. Thanks to my friend and colleague, Stephanie Barclay, for fielding all of the good questions. These questions and topics are obviously live, and the discussion about them will continue, but I think we've been given some great food for thought and some really helpful propositions and principles that we can use to frame our own thinking about these matters. So thanks very much to Notre Dame Law School and to Notre Dame Law School's London facility and the Global Lawyering Initiative. And again, thanks to all of you. And this will be recorded, and we will be signing off now.